Thank you, Mr. Commissioner. My name is Ware Wendell. I'm the Deputy Director with Texas Watch. Texas Watch is a citizen advocacy organization, a nonprofit, nonpartisan, representing over 20,000 Texans statewide. And as you know, much of our work concerns the protection of policyholders. I first want to thank you for convening this meeting. This is a big issue, and it deserves a lot of scrutiny and careful thought. I've just given you a binder with quite a few materials. I know you to be a very careful lawyer, and so I wanted to give you all the best information that I could. And I won't repeat everything that's in that binder because I trust that you will be going through that. I will touch upon some of the highlights of that testimony. You have extensive written testimony in the binder as well. Let's be clear about what's taking place here. The insurance carriers fought last session for the Texas legislature. They fought very hard to change Chapter 541, Chapter 542 of our insurance code. The legislature heard those arguments and rejected them in full. Senate Bill 1628 was defeated and never was considered by both chambers. They lost in the legislature, and now, Mr. Commissioner, they've put you in this very tough position of asking you to take unprecedented action that none of your predecessors have ever undertaken. Your predecessors, through many administrations, on both sides of the partisan aisle, have heard these arguments and rejected them, and I believe they've rejected them for good reason. I'm holding in my hand the review requirements checklist for residential property that's posted on the TDI website. And it goes very carefully through different types of coverage options, and it instructs the TDI personnel as to what to be looking for, what's permissible, what's impermissible when companies are filing forms. And yes, they do have form freedom, but Mr. Commissioner, you have prior approval under Chapter 2301 of the Insurance Code. Under arbitration, it says limited to coverage disputes, and then it goes on to say voluntary post-dispute arbitration only. Maybe either binding or non-binding. So what's being asked of you, Mr. Commissioner, today is a radical departure from post-dispute arbitration, where both parties now know what the issue is, know what the dispute is. Frankly, have had the ability to ascertain their legal rights through the advice of counsel. They know what the lay of the land is. As Mr. Covarrubias just said, if they then want to arbitrate, they have every option right now to opt into arbitration. But what Texas Farm Bureau is asking of you is that consumers give up that right on the front end before they really understand what could happen in the future. We feel that this would create instability in the marketplace. Let's be clear, if Farm Bureau is successful in getting this endorsement through, there will be a stampede by carriers to your board, Mr. Commissioner, asking for their own arbitration endorsement. I feel very confident in saying that. I believe that it would imperil not only people's shelter, because if people are not adequately compensated following a loss, they cannot be billed. So that is a problem for the housing stock of the state. But it also imperils their greatest source of wealth, which is their home. For most people who work for a living. And in doing so, when people can't rebuild in their homes, people can't go back to work, businesses suffer, it has a ripple effect throughout the entire economy. Insurance is not your average product. Policies are not your average contract. And you know this very well through all of your many years of work in this area. Insurance, unlike other commerce, is state regulated under McCarran-Ferguson. And that law casts a very long shadow here. Yes, the Federal Arbitration Act casts a long shadow, but McCarran-Ferguson reverse preempts. I gave you extensive cites, and I believe 36 in my written testimony, showing you many cases where this issue has come before the courts, and they have said that states have the right to make up their mind about arbitration within the insurance context. There was some talk about what the legislature has done on the issue of arbitration, and that was in the context of TWIA. you know, Mr. Commissioner, TWIA is a quasi-governmental entity. What was done in TWIA was done in a special session, and it basically involved issues of sovereign immunity, if you will. And so let's look at the entire architecture of the laws that have been passed by the legislature. And I think that the legislative intent here is very clear. The legislature wants to protect Texas consumers. They want to protect policyholders specifically under our insurance laws. In Chapter 31 of the Insurance Code, you're directed to, quote, protect and ensure the fair treatment of consumers, and, quote, ensure this code and other laws regarding insurance and insurance companies are executed. That's 31.002. That's important, and I'll come back to that in just a second. And then, of course, Chapter 541 concerns unfair settlement practices, deceptive practices by companies that have passed the DTPA, maintain the DTPA, that passed 542 under the Insurance Code, requiring prompt payment of claims. The Texas legislature is very clear. They want TDI to protect consumers from insurance predation. That's what it comes down to. The standard under 2301 is that you're to protect policyholders from property casualty forms that are, quote, unjust, unfair, inequitable, misleading, or deceptive. And you have disapproval authority for forms that contain, quote, a provision or has a title or heading that is unjust or deceptive, encourages misrepresentation, or violates public policy. And for the reasons that I'm going to give you, we believe that insurance arbitration, pre-dispute binding insurance arbitration, violates that very standard. There are many problems with consumer arbitration, and those are only heightened in the insurance context because insurance is not a commodity. It's a necessity as a condition of our mortgage. We have to maintain insurance. We have no bargaining power. If you're looking at the demand and supply curve, the demand curve is set. We have to buy a product. The only question is from which company. Arbitration favors repeat players. It has significant process defects concerning cost and lack of discovery. It creates confusion. And I want to drill down on that point because you asked about that in your initial comment. It's conducted in secret, and it is essentially unappealable. You know the standard to try to argue that arbitration award was incorrect. It's manifest disregard for the law. I mean, you basically have to show that the arbitrator tried to get it wrong, which is in practice impossible to prove. So the Consumer Financial Protection Bureau recently concluded a study that I think is probably one of the most comprehensive studies ever conducted to date on consumer arbitration. And I want to give you some of the highlights. In your binder, you have a disc that has the entire 700-page study. I've printed in the binder just the executive summary, frankly, just to save your back and to save a few trees. But some of the highlights, they looked at 341 cases filed in 2010 and 2011, and consumers obtained relief regarding their affirmative claims in 32 disputes. That was the win rate, 32 out of 341 cases. Companies, on the other hand, of the 244 cases where they made claims or counterclaims, obtained relief in 227 disputes. Their win rate was 227 out of 244. Consumers in those 341 cases recovered, $172,000 in collective relief. Companies recovered collectively $2.8 million. Arbitration favored the companies. It disfavored the consumers. That's unjust in toto. I've given you a number of leading arbitration studies. I've cited more in the footnotes of our written testimony, but I wanted to touch upon a few. Yale Law professor Judith Resnick in the Yale Law Journal recently wrote, and this is an article entitled Diffusing Disputes, arbitration, quote, strips individuals of access to courts to enforce state and federal rights, strips the public of its rights of audience to observe state-empowered decision-makers imposing legally binding decisions, and strips the courts of their obligation to respond to alleged injuries, and I'll come back to that. The Georgetown Law Journal recently, Professor David Hortman, looking at AAA and complaints filed about AAA's consumer process, and you have this in the binder, says, quote, frequently arbitrating entities win more and pay less in damages than one-shot entities. That's what's called the repeat player phenomenon. John Q. Homeowner will see an arbitrator hopefully never in his life from our position, but once in his life, if this endorsement should go through, Texas Farm Bureau will see them routinely. And that dynamic can really distort the process. It's totally unlike what we see in our courts, where we have open courts, judges who have to stand before the scrutiny of the public, and you've been held to that standard your entire career as a dedicated public servant. Arbitrators conduct all of their work behind closed doors. St. John's researchers have conducted a really interesting study, and I want to really highlight this for you because you asked about disclosure, Mr. Commissioner, if you'll indulge me. They showed a typical consumer contract containing an arbitration clause to folks. They sat them down, put it in front of them. It was printed in bold with portions in italics and capital letters, everything you could do to make it conspicuous. And then afterwards, they questioned them about their own experiences with actual consumer contracts. Here's the takeaway. After being made to focus on this, 43% of respondents recognized that the sample contract included an arbitration clause. 61 of those believed that consumers would, nevertheless, have a right to have a court decide a dispute too large for a small claims court. Less than 9% realized both that the contract had an arbitration clause and that it would prevent consumers from proceeding in court. They did not understand what they were reading. They're not lawyers like you and me, Mr. Commissioner. They have other concerns in their life. Ultimately, of the more than 5,000 answers recorded to questions that offered right and wrong answers, only a quarter were correct. They did not comprehend it. This was a conspicuous disclosure. They did not know what they were reading. And these were people who were just made to read this. They didn't have to live in a damaged house afterwards and suffer the consequences of insured delay. It's for reasons like these that the Texas legislature has required consumers to receive the advice of counsel and agreeing to arbitrate other disputes outside of the insurance context. And of course, that's in Chapter 171 of the Civil Practice and Remedies Code. This is being presented to you as an option. Consumers can take it or leave it if they want some money off of their premium, so be it. Let's be honest here. And agents are going to be incentivized to sell this arbitration clause. Again, there will be a race to the bottom. Many companies are going to want this. This will be the default position. You just heard from Mr. Kokorubius as a representative example. People are hurting right now. They're cash strapped. Their premiums are high. If given a chance to lower their premiums, they're going to jump at that chance, even if it hurts them, because they don't understand what they're signing. And that has implications for not only their family finances, but our business environment and our economy as a whole, as I've talked about. The New York Times has conducted extensive research into this and done very good reporting. You have all of that in your binder. Here's the takeaway. Quote, in recent years, America's corporations have created a private system for handling disputes that benefits them greatly while denying consumers their day in court. Corporations effectively control the arbitration process, including the selection of the arbitrator and the rules of evidence, a stacked deck, if ever there was one. The legislature has spoken very clearly here about Chapter 541. If you search Chapter 541, and again, for those in the audience, this concerns unfair insurance practices. The word court is stated 63 times. Disputes are to be resolved in court. If you search Chapter 541 for the word arbitrate or arbitration, it's mentioned 0 times. The legislature wants these disputes to be resolved in court. The legislature here is regulating the business of insurance under McCarran-Ferguson through Chapter 541. You know this well as a fundamental point of statutory construction. Legislatures, when they take legislative pen in hand, speak with a very particular purpose. The words that they choose to use and the words that they choose not to use have effect. They matter. The Texas Supreme Court spoke to this in 2011 in TGS versus Combs. TDI has long understood the difference between consumer arbitration and commercial arbitration. You can go through all the different checklists for different policies, whether it's life settlement insurance or title insurance. Consumers are treated differently for good reason, because of the unequal bargaining power, because they're not as legally sophisticated. They're not lawyers. They don't know what the effect of all of this is. I've talked with you some about McCarran-Ferguson. Let's think this through. If Farm Bureau is able to resolve which is to say dispose of most of their disputes through arbitration. They're going to be doing that in a process that you, Mr. Commissioner, will have precious little, if any, information about. You will have no idea as to what the genesis of that dispute was, what the merits of that dispute were or were not, and it imperils and handcuffs your ability to regulate the market, to conduct market conduct examinations. How can you do your job if they're doing this in the dark? Again, they're putting you in an impossible position here by asking you to do this. Farm Bureau and other industry actors have alleged that they're being deluged with policyholder lawsuits that are meritless. I gave you in tab 4 of your binder all of the existing penalties under the Insurance Code, the Deceptive Trade Practices Act, the Civil Practice and Remedies Code, the Rules of Civil Procedure, the Penal Code. There are a whole host of ways to kill frivolous lawsuits. I'm an attorney. I'd like to think that I'm a good attorney, that I help people. I want frivolous lawsuits killed. I want bad lawyers put out of the practice of law. I would say to Farm Bureau and to the other industry actors here in this room, if you're presented with a case that is meritless, kill the case. Move to dismiss the case. Kill the case on summary judgment. Seek sanctions. Please do that. But if you're not able to do that, if you talk with your counsel and your counsel advises that you should not do that, then we're left to conclude rightly that there are live, colorable claims that are ripe for resolution in our courts. That's the way our system works. Nobody knows this better than you, Mr. Commissioner. There's a reason why Farm Bureau feels it can offer a, quote, discount to consumers, and your staff has noted this. We received the documents. The discount would only be equivalent to the rate increase that Farm Bureau is imposing on their policyholders. So it's really not a discount. It's illusory in that example. But nevertheless, it's because this process is going to disfavor consumers. Consumers are not going to be able to build their case fully through discovery. They're not going to be able to understand completely the extent of the wrongdoing. More importantly, the decider won't. As we've seen from some of these empirical analyses, awards will be lower, or in many cases will just be disposed of. And that's an injustice. That's an injustice. It's unjust. It's deceptive. It's unfair. If carriers wish to lower their loss adjustment expenses, there is one foolproof way to do so. Pay 100 cents on the dollar and pay claims on time. If you simply do that, you have zero liability from the policyholder. That's, of course, the purpose of the penalties that we have in the code, to incentivize companies to do the right thing and to perform their obligations. Farm Bureau is asking to allow the camel's nose into the tent. Mr. Commissioner, the tent will come crashing down on all of our heads if this is allowed. I'm very concerned about what this would mean for consumers, for the economy as a whole. There's a reason why your predecessors have never done this. There's a reason why other state insurance commissioners do not do this. It's because it's dangerous. It's very dangerous. And I would ask you to please follow the lead of your predecessors from administrations throughout the years and deny this request for arbitration. Thank you, Mr. President.